When you hear the word lease, you think it's just one thing. Now, that's wrong. Lease is a generic term. In property law practice, the word lease is used to describe three transactions: one, tenancy; two, sublease; and three, lease. So in a scenario on lease, you must be careful to identify whether it is lease, tenancy, or sublease. And the best way to do this is to first have a general understanding of the definition of lease. Lease is a transaction whereby the owner of the property transfers exclusive possession for a term of years to another party in exchange for rent. So the exclusive possession of a property is transferred for a term of years. The term of years here means number of years. Now, this term of years is very important in identifying whether it is lease, sublease, or tenancy. Listen carefully. Now, if the term of years, you can call in number of years for your understanding. If the term of years is 3 years and below, we are talking of 3 years, 2 years, 1 year. The transaction is tenancy. Now, if the term of years is above 3 years, we're talking of 4, 5, 6, and above, the transaction may be lease or sublease. You must be careful. A lot of students will say the transaction is lease, but that's wrong. The transaction may be lease, it may be sublease, depending on the nature of interest. Finally, in the mode of creation, it properly distinguishes these three transactions. Where a lease is created for 3 years and below, I'm using the generic word lease, created for 3 years and below, it must be created in writing or orally. Now, if a lease is created for above 3 years, it must be created by deed. That's why we have tenancy agreement, because a lease for 3 years is created in writing or orally. Then we have deed of lease and deed of sublease, because a lease created for above 3 years must be by deed. Now, I believe you have learned something today. If you want to see me again, you know what to do.